續。
Let's resume. Just now, the deputations have already given us their views. All in all, they supported the bill. Yes, Mr. Wong. Yes, I'd like to thank the HKIAC's recommendations and also the two streams of legal professions comments. We are grateful to that. Yes, deputations, we have heard your comments, and I understand that you are very supportive of the bill. Members, do you have any questions that you'd like to put to the deputations? The two members here. Ms. Priscilla Leung? Nothing? Okay, so we may invite the deputations to leave. All right, thank you very much.
Members, do you have any questions on the principles of the bill? Okay, no questions. Then we can go into clause-by-clause examination. Which official will take us through the clause-by-clause examination? Mr. Wong. In the long title, we have said that we seek to adjust the circumstances under which the opt-in provisions in Schedule 2 to the ordinance do not automatically apply, and we update the arbitration parties to New York Convention order. Short title, that this ordinance will be cited as the Arbitration Amendment Ordinance 2015. Sorry. You can hear me, right? But you cannot hear him. Part 2. Clause 2, we will amend sections 3 to 7, and clause 3, section 23 is amended, and that has to do with Article 10 of the UNCITRAL Model Law Number of Arbitrators. What is important is repeal subsection 3, so that when we read 23 bracket 3, we will know very clearly that when Schedule 2, Section 1 does not apply, then the number of arbitrators will be decided by the Hong Kong IAC. Clause 4, this is the crux of the amendment bill. This has to do with Section 102 of the ordinance. Section 102 will become 102 bracket 1. And then we are going to do something to 102 bracket 1b Roman 2. As I said, sections 2 to 7 of Schedule 2 will be depacked from subsection 1, and we are only going to preserve 2 to 7. The effect will be that in an arbitration agreement, if there is an express provision on the applicability or otherwise of sections 2 to 7 of Schedule 2, then the automatic application mechanism will not kick in. In other words, if the agreement mentions the number of arbitrators, that will have no effect on the applicability of any sections in Schedule 2. This is the main purpose of the amendment bill. Any questions? Please continue. Clause 4, bracket 3, this is to clarify that this will not derogate from the operation of Section 99. Section 99 states that in the agreement, the applicability of certain sections has to be provided for. Apart from automatic application, Section 99 must be expressly provided for before it can apply. But the amendment this time around will not have any effect on the express provision for Section 99 to be applicable. If in the arbitration agreement it doesn't state whether domestic or international arbitration rules will be used, then what would happen? Chairman, the automatic applicability of Section 100 will apply to domestic arbitration. If it is not stated that it is domestic arbitration, then you have to go for Section 99. In other words, the automatic application of Section 100 will not kick in. Please continue. Clause 5. What is important is bracket 3, that is a transitional arrangement. We will explain that later on. Clause 6. Schedule 2. Section 1. After the depegging, there will be express statements saying that if the parties to an arbitration agreement fail to agree on a number of arbitrators, then it would mean that there will be one arbitrator. And that actually is the existing arrangement. Any questions? If not, Mr. Wong, please continue. Clause 7, a transitional provision. In Part 2, we separate that into 1 and 2. And after the amendment bill is enacted, there may be situations arising that require transitional provisions to apply. When the bill will become the law, if arbitrations have started before the bill is enacted, then they will not be affected by the amendments. In other words, only after the bill is enacted and arbitrations then start, then they will be affected by the amendments. That's correct. Please continue, Mr. Wong. Under Part 2, subsection 2, under 1, we have certain definitions or related proceedings, and also Article 21 of the Ancestral Model Law. And we are clarifying the legal wording, but the crux of the matter is that the bill as enacted would apply to arbitration cases that start after the bill is enacted. You have this term pre-amended ordinance. How many amendment bills there have been to this ordinance? Is this term at all clear? Can you explain that to me? What you mean by pre-amended ordinance, and why do you have the definition here? Cap 609 was enacted end 2010 and it came into effect in June 2011. There was one amendment in 2013. This is the second time that the ordinance has been amended. When we use the term pre-amended ordinance, we mean the sections that are effective before this amendment, meaning that that would include amendments made in 2013. Right, that's clear. Any other questions? If not, please carry on. Part 3, an updating to the arbitration parties to New York Convention order. We have a few new countries. There may also be some change in name. Bolivia becomes Bolivia Plurinational State of Bolivia. And the United Kingdom has added British Virgin Islands to the schedule. There are 4 other countries that are new: Bhutan, Burundi, Democratic Republic of the Congo, and Guyana. Chairman, we know that there is another updating, and we'd like to add that in, and that is Palestinian state. We are going to move a CSA in order to add that in. Legal advisor, any questions with the CSAs? Well, this is only a draft at the moment. I don't think it is problematic in any way. it is also in line with the scope of the amendment bill. So it is within the scope of this amendment bill. My question for you is, Part 3 is actually a part of the principal ordinance. That means whenever there are changes of names of countries or addition of countries, we have to amend Part 3. Is that right? Chairman, we can do it either way. If we are doing an amendment exercise to the ordinance, we can take the opportunity also to update the order. This is actually bylaw A of Cap 609, and we can also do it under Section 90, and that is the CE in Council can also amend it. Okay, any questions, members? No? Is it that we have completed clause-by-clause examination? Yes, indeed. The clerk, the list, Mr. Wong, he went through it quite quickly and he mentioned the UK. It is said that British Virgin Islands will be added. Now you list everything out, but most people would just say BVI. What is the significance? Mr. Wong. Chairman, we follow the list of names in the New York Convention. We also consulted the Ministry of Foreign Affairs. Well, this has to do with the applicability of an international convention to Hong Kong. We believe this expression is appropriate. This is what we usually say about the names of countries. Is it that only sovereign countries can be cited? It is not like the WTO. Well, no, I'm just trying to understand the situation. We don't usually know what BVI is, but you cross it out and you put in all the names. Are there any particular connotations here? Thank you, Ms. Leung. This is a new part. In the original list, under the UK, you have Bermuda, etc. But in the ordinance now, we do not have BVI. Since BVI has been added to the convention, we are adding it in. The convention uses the long form of BVI, so we just follow suit. So we are also adding in British Virgin Islands. This is an addition. These names like Bermuda, British Virgin Islands, they are subsumed under United Kingdom of Great Britain and Northern Ireland. Is that right? They are territories belonging to the UK. Since we are on this, I'd like to ask about Palestinian state. This will be included in a CSA. Is that really a country? You have consulted the Ministry of Foreign Affairs. Is it a sovereign state? Chairman, the procedure is like this. We are aware that the Palestinian state has become a member state of the convention starting from the 2nd of January, and we count 90 days. So on the 2nd of April, this will become effective. We have consulted the Ministry of Foreign Affairs, and it is said that we can add this in, and if there is any arbitration work to be done, this can be enforceable. Right, any other question? If not, let us look at our legislation timetable. Mary? Sorry, speaker not coming through. So the quickest is for us to report to the House on the 20th of March. And then it is up to the government to resume second reading debate at the Council. Thank you very much. Anything else, Ms. Priscilla Leung? A small point. I know what you said about BVI, but we also mention this term in other ordinances. Does it mean that you should also use the long form? We have experienced this before. In other words, you amend a certain bill and then you have to make complementary or consequential amendments to other ordinances. Is this the case that we are doing this for the sake of arbitration only? Since we have subsumed this under sublet A, and this is related to section 90 of the ordinance, the thing is, if under sublet A we put this entity in, then we can have mutual enforceability. That is a legal obligation under the convention. And I can add that this is only about section 90, bracket 2, the enforceability of arbitration agreements. This doesn't have an effect on general legal expressions. And of course, we have to follow the name list of the convention. And I don't think there is an effect on matters not relating to section 90 in sublet A.
Yes, I understand that. But then during the last term, there was also a similar situation. We tried to amend a particular ordinance, and this might have been added by the UK, right? So is it that it will be their future practice as well? So are they going to change any expressions in a similar manner in all future situations? And in other ordinances, we also have reference to BVI. This is the first ever ordinance that we are using the long form of BVI, because BVI is a very common name representing this particular jurisdiction. So does it mean that there are certain islands that have not been included? So why are they listing that out now? That's why I'm bringing this up, because in cross-referencing, in future, where there are similar pieces of legislation, does it mean that the UK has already taken the initiative to list out the long form, and therefore in the future we will have to do the same, so that whenever there is any reference to BVI in other ordinances, or there might be policy implications. So this might be the first one that we are listing the long name here. This is about arbitration. Is that the case? Mr. Wong, Chairman, we just follow the Ancestral web page, and they have used this name, British Virgin Islands, in their official website. That's why it is our obligation to follow their expression in implementing this. And after consulting the Ministry of Foreign Affairs, they also are of the view that this practice is appropriate. I understand that. Maybe you're not in a position to answer my question right now, but then can I draw your attention to this, so that in the future, well, with regard to this definition, does it mean that in the future, whenever there is any reference to BVI, it will have to be changed to this long form? That's my concern. What my brief response is that this would only affect the New York Convention's application, and therefore it should not have any impact on other pieces of legislation. Of course, when other international conventions are applied to Hong Kong, they might also have a similar description of the islands. But then in terms of the name, we should follow the expression shown in their official website. But then when we pay tax, there are cases involving parties paying tax to BVI. So does that mean that we will have to follow the practice in the future, so that we will not be calling it BVI, but the long form? Well, to follow up on Ms. Leung's question, well, as far as our domestic legislation is concerned, no, we are not referring to international conventions. If we are one of the places where such international conventions apply, then we will have to follow the expression in the international convention. But then, under the laws of Hong Kong, are there any ordinances referring to BVI or British Virgin Islands? Do we have such references? If you are not able to answer it right away, can you provide us with further information later? As to any references made to BVI or British Virgin Islands, yes, under the New York Convention, yes, I understand that we have to follow their expression so that British Virgin Islands is one of the jurisdictions under the UK, but then I think Ms. Leung's concern is whether or not this will also apply to other ordinances. So, Ms. Leung, do you have anything to add to what I just said? Yes, I'd like you to do some research and give me an answer. Yes, our legal advisor would also like to supplement. Yes, thank you, Chairman. Very briefly, I tried to search the DFJ's commercial law information system, and there is no reference to British Virgin Islands, and whenever there is reference to the UK, it would just say United Kingdom. But then I've never seen such detailed descriptions, including the names of the islands and so on. So that's for Ms. Leung's information. All right, thank you. Yes, Paul Chair, we have just completed the clause-by-clause scrutiny. Do you have any questions that you'd like to put to the administration? All right, thank you. As I said just now, we intend to submit a report to the House on the 20th of March. And if you have any further questions, we'll deal with them in writing. All right, thank you. Thank you, government officials. Meeting is adjourned.